Good morning, everyone. Welcome to our webinar. We're just going to give it one quick second while everyone is joining. We had a lot of people sign up for this webinar, so we know that this is a topic that is on a lot of people's minds. So just give us one quick second and we'll get to your starting. Okay, I think we can start. Welcome, everybody, and thanks for joining us today on July 16th, 2026 for our Ask the Experts Wage and Hour Issues webinar presented by Ethos Human Capital Solutions. My name is Denise Ketty, and I'm going to be your moderator for today. Today's session is going to cover California wage and hour rules because we know they can be very complicated and even a small mistake can become expensive. So today, the webinar, we have a unique opportunity to look at these issues from three perspectives: the HR perspective, legal counsel representing the employers, and legal counsel representing the employees. So just as a quick reminder about our session today, Linda, you can forward the slide. Today's discussion and accompanying materials are for information purposes only, and they are not legal advice. Every workplace situation is different. Everything you encounter is different. Please consult your qualified legal counsel regarding your specific situation. And I'm going to go into a few housekeeping notes for today. Our webinar runs approximately 60 minutes. Please submit your questions at any time using the Q&A area on the bottom panel. If you want your questions sent to a specific person, please make sure you mention that in the question when you do it. We'll answer as many questions as time will allow. If we don't get to your question today, you can reach out to our presenters. We'll put up that information, their contact information at the end. Again, today's session is being recorded and the recording will be posted to the Ethos YouTube channel in the next 24 hours. You can download the slides using the links provided. You can ask questions, as I mentioned, in the Q&A section. I will also drop in the slides handout link into the chat a little bit later on in today's session, so you get it. So let us introduce today's panelists. Linda Duffy. Linda, of course, is going to talk about things from the HR perspective. Linda is the founder and president of Ethos Human Capital Solutions, and she has more than 30 years, or wait, she updated her slide, 40 years of human capital experience.
That's a lot.
Yeah, and leads a team that provides HR consulting, recruiting, training, payroll support, and organizational development services for your company. Linda helps business leaders put the right people, systems, and workplace practices in place so they can reduce risk and focus on running their business. She brings practical HR perspective to today's conversation, including what employers can do to prevent wage and hour problems before they grow. She and her team bring the magic of human connections to everything that they do and all their clients. And our fun fact for Linda today, she is our chief Angels fan, and she just welcomed a new puppy into her family. So if you don't follow us on Instagram, do, because we'll be putting pictures of the new puppy there. Our next presenter today is Michelle Baker. Michelle is going to be on the employee side legal perspective, or known as the plaintiff side. Michelle is the founder and managing partner of Baker Law Group. Since 2002, she has focused her practice on representing California employees in matters involving unpaid wages and overtime, meal and rest period violations, discrimination, retaliation, and other workplace rights. Michelle has handled complex litigation throughout her career and regularly speaks to professional organizations on employment law. She brings the employee side perspective, including the mistakes and practices that can lead for employees to seek legal help. Fun fact about Michelle, she's married to a defense attorney, so we can imagine what those conversations are at night. And then, of course, our friend Joe Naddour, who is representing the employer side legal perspective as a defense attorney. Joe Naddour is the founding partner of Larsen Naddour LLP. He has practiced employment law exclusively for 15 years and has been recognized as a super lawyer multiple times. Joe represents California employers in employment litigation, including wage and hour claims, wrongful termination, harassment, discrimination, retaliation, leave, and disability accommodation matters. He also advises employers and HR teams on day-to-day compliance. His philosophy is simple: the best lawsuit is the one an employer prevents. And if you read Linda's newsletter, a fun fact about Joe is if you read her newsletter, last month we showed Linda was able to bring the game ball out during the Angels game because she's our number one Angels fan. And Joe was the person who gifted her with that opportunity. Okay, so thank you. Oh, I forgot about HRCI credit. HRCI credit. If you need HRCI credit, today's program, as most of our webinars are approved for an hour of HRCR credit, you have to take the survey in order to get your credit. So please just follow that link. I'll also stick it in the chat in a few minutes so that you have that. And now we can transition to Linda, Joe, Michelle. Thank you for joining us today. We look forward to a very candid conversation as we had before we started this. You want to get us started, Linda?
Absolutely. Welcome, everybody. We're very happy you're here. And I sincerely appreciate both you, Michelle, and you, Joe, for joining us because um, it's so much fun to talk to people that have differing points of view, although probably similar in a lot of ways, just the flip side of the same coin, right? So for everybody in the audience today, it's going to be a little bit of a different style. We don't have any content slides or anything like that. It's more about talking with these two, asking them some thought-provoking questions, hopefully, so you can really start to understand how a plaintiff's attorney thinks, how she evaluates a case, and then how a defense attorney is going to approach defending the company. So we're going to jump in and, I will just remind everybody, one attorney spends every day looking for employer mistakes and the other one spends the day defending them. So if they both agree on something, you might want to make a note of it because it's valuable information. So I want to start by really learning more about how you guys think as attorneys, right? So Michelle, let's start with you. Someone calls your office and says, I think I have a case, right? Before they finish even telling the story, like what's going through your head? What are the things that you're listening for, the things that you want to know?
So what's a little bit different for me, and I actually am going to describe what I understand other plaintiffs' lawyers do as well. Do I like the person? That's number one, because if I like the person, inevitably the trier of fact will like the person. That's what's going to sell the case. Because what you have to really look at is it's a personality contest. And what employers, you may think, hey, this employee, they're not going to present well, so I'm not going to be concerned, right, about this potential employee that I want to just terminate. Um, but do not forget, lawyers that go all the way to trial, they also spend a lot of time reshaping how that plaintiff could look. I'm not interested in doing that, but I want to tell you that that is what's going on behind the scenes. So I think about, is the person trustworthy? Second of all, I'm going to absolutely be looking at what documentation is there to support this person's case. And this is not just paper documentation, right? We live in a day of electronic communications. It's pictures, it's text messages. What is there? And then next best, or not, yes, I prefer written documentation, but then I'm also looking at if there's not, sometimes there may not be, what other witnesses support what this person's saying and how do they present? So those are what I am looking at in evaluating the case.
Tell us this also, like what's a red flag? Like for you as you're evaluating whether to take the case or not, what's like that first red flag? You're like, okay, wait a second.
This answer is different than if you asked me this even 3, 4 years ago. It's AI. Okay. So you've got a lot of people now that are speaking to AI and are formulating their case based on what AI is saying.
Hmm.
And Linda, I almost would almost go back to you as well, because from a companies are at a disservice if they do not consult with, and this is not plugging for anybody, which is certainly not me,
Feel
but
free
I'm
to
just saying
plug
whether
away,
that's
but go.
Joe or you, Linda, whether it's your legal counsel who understands employment law. That's
Right.
what's very key. A general practitioner is going to make mistakes. Employment law is very nuanced in this state. So whether it's first having an HR consultant and then next, and really even in combination with, and I think a lot of times you have HR consultants that do have their go-to lawyer that they could speak to, because there is no way that in-house is going to be able to know how's the best way. These employees are coming armed not
Mm,
just to me, but to the company themselves with erroneous knowledge from AI. So for
mm,
me, it's a red flag. And by the way, in case I don't care, I'll tell you, what is it? What's the first step I do? So all of my business is referral based. Okay, so someone picks up the phone and talks to me. But sometimes I guess you get my website and you could submit your story. And it says in there, do not communicate with me by using AI. So when they fail that
interesting.
test, oh, trust me, you're coming in already one step behind that eight ball, right? I'm like, dude, do you not listen? It said don't use AI. So that's a big problem because AI is not accurate in its assessment. And my God,
Yeah,
especially even for wage and hour law, or let alone disability, have I been discriminated in the workplace? So for me,
yeah.
that's what a red flag is.
Okay, awesome. So, Joe, on your side, finish this sentence for us. I knew this case was going to be expensive when I saw what?
Probably the most hated word in employment law, which is called PAGA, or the Private Attorneys General Act. And so perhaps some of those of you listening have gotten one of these dreaded letters. And if you have 5 or 10 employees, it's not too concerning. But if you've got the more you have, the more concerning it is. And that's because PAGA is a law that allows one employee to sue on behalf of all employees. And so, regardless of whether the other employees have any say on it, it's essentially a class action. It's a little different. And those lawsuits have been rampant lately. And so oftentimes I'll speak with companies and they say, we did nothing wrong. This was just a bad egg. He's the outlier. Everyone else is happy. But if you get that letter, that dreaded PAGA letter, it really doesn't matter because they're going to be suing on behalf of everybody and they're going to be requesting records from everyone. And so it automatically becomes a very expensive ordeal, which is why you need to prepare beforehand because under recent revisions to the PAGA law, if you take all reasonable steps, you can cut the maximum PAGA penalties from down to 15%. And so these PAGA penalties, depending on which lawyer is arguing, they can stack them easily millions of dollars. And so cutting it down to 15% if you take all reasonable steps, even if you make a mistake. But if you show that you've taken all reasonable steps, you have an argument because the other side never agrees to it. But you can make an argument that penalties are capped at 15%. So you want to avoid getting the PAGA letter. You want to avoid a current but mostly former employee going to Michelle. Michelle would be fine, but the other lawyers are the ones you just don't want your employees going to lawyers. That's step one in the defense.
Right.
And can I
Yeah,
say something in addition to
absolutely.
that? Is because what I'm also and I could be I'm going to use a word I could be guilty of this as well. Someone comes to you and they may just think I've been retaliated against or I've been bullied, right? We all know bullying in the workplace is not illegal as long as you're not targeting that person that the victim of being a bully for their protected status. But put that aside. A lot of people like to call saying someone's mean to me at work, okay?
Right.
What a lot of lawyers do, though, is like, okay, I'm not hearing anything. Let me see your pay stubs. Okay. That's a majority of people who are advertising on those billboards and, just however one advertises for
Yeah,
getting plaintiff's cases, right? Whether or not the plaintiff or potential plaintiff makes any complaint about wage and hour concerns, they're just going to simply ask for the pay stub. Okay. And the time
exactly.
records. And for me, when I had said I can kind of be guilty of this, is yes, when someone's describing to me, I'm like, okay, well, why do you think you've been a victim of being a bully? Blah, blah, blah. That person may inadvertently say, well, I'm being picked on because they want me to work off the clock and I don't want to. I've got a child at home and I need to go home. That's going to trigger for me. Wait, what? And that's not what
Right.
they called me for. And then I'm going to evaluate it going, is this truly a problem? Some companies are bad. I'm sure no one on this, that's why they're here participating in this webinar. Uh,
Exactly.
but just true, by the way. They wouldn't be mistreating their employees in that way, but there's a lot of companies that just don't care and they do abuse their employees. And yes, I very well can pick up on something, hear that, and I'm now going to go down that rabbit hole, which is not what the person called me for.
Right.
Anyways, I wanted
Exactly.
to add that.
Yeah. That's a really good point. So let's take this conversation a little bit further to understand how you guys think. So
Mhm.
let's take a look at something that happened actually this morning. I woke up and I was looking through my emails and my texts and everything, and I had a client um, text me and say, "Hey, I was going to fire this employee today, but she called out sick. If she calls out sick again tomorrow, can I go ahead and basically fire her over the phone and overnight her paperwork and her final check to her?" Right? So before I share how I advise the client, right, what are some of the facts that you would want to know, Michelle, if you were evaluating, hey, does this employee, would she have any sort of case if in fact she gets fired? And then Joe, you on the defense side, like what would you want to know? What would you look at?
So this is again, so from um presumably, if the employee in that situation contacts me, they're not going to know, right? That their head was on the chopping block. Okay. So that's where it's key. So someone comes to me and says, "Oh my God, I called in sick." And guess what? The next day I was fired. So I'm going to find out what did they call out sick for. So what's interesting about what I just said is, as you know, the state of California says you get your what I call it could be 5 or 10 days of don't ask, don't tell, right?
Right.
And but true disability discrimination, you have to have a legitimate reason to be out and be. So I hope to God the person who called out sick literally was truly unable to work because of an illness, and that doesn't cover colds, okay? So, assuming we get over that hump, because if the person just says, "Oh no, I just called out sick because I didn't feel like working or I drank too much the night before," okay, so what? There's no case there. But the person says, "No, I just got a cancer diagnosis and I couldn't, and I had to go have a procedure that day." Oh my. Okay. Geez, it sounds like it is disability discrimination. And then I think this is perfect. I'll hand it off to Joe because that's when Joe needs to come in and contact me, whether it's a demand letter or a call or a lawsuit, to say, here's the documentation, right? Everybody who's on this webinar, y'all know documentation's key because when you've got documentation of poor performance and literally, "Hey HR, I want to fire some supervisor. I'm going to fire this person tomorrow," and that's dated before learning of the sickness, company's protected. So,
Yeah, the two words I wrote down are, and probably the answer to 90% of the questions are documentation and communication. So employees are smart and they can get a feeling, in my experience, of when companies are about to terminate. People start looking at you different. There's a different feel. Maybe you're not inviting them out, afterwards or out to lunch like you would have before. So the key is once you start realizing that their performance is not up to speed, you have to document it in some way. And that's uncomfortable to a degree. And it's even more uncomfortable communicating that with the employee because maybe you don't want to be, so aggressive or every time, everyone makes mistakes. And so you don't want to, document, email them, "Hey, Linda, you got this assignment to me 2 hours late. And so we missed the deadline," especially in smaller offices, but you need to document. So if in that situation an employee did call out sick, and that does tend to happen because they're figuring it out, I'd want to know what documentation was there before just about performance. And in a perfect world, I'd want to know as soon as you make the decision to terminate, I want something in writing that says you made that decision. because it's very rare you make the decision and you fire immediately, right? Usually you got to get your final paycheck, final paperwork, pay out the vacation, go through payroll. It takes time. Check with the manager, see if there's any deadlines, who's going to cover that. So once you make that decision, put it in writing. Even if it's in an internal email, just to say that as of July 16th at 11:22 a.m., we're moving forward with the termination. So that if anything happens after that, right, whether it's a sick leave or they complain about harassment or they go on a leave or they file a workers' comp claim, you can say, well, we made this decision at 11:22 on July 16th. I've even had an example when clients don't do that because that's a little wishful thinking. I had a client put a job advertisement for that same position as of this day. And so we've been able to use that to say, listen, look, obviously we're going to fire her before. And so that documentation is helpful. It's not perfect, but it's helpful.
Yeah. Yeah. And that
Absolutely.
was actually another question I was going to ask you guys is how do you feel about delayed terminations, right? Under what circumstances would it be acceptable? I had this happen a couple weeks ago where somebody caught an employee stealing on camera. They hadn't asked him about it, but he was, removing items, let's just say that he shouldn't have been removing, mostly like food and stuff like that. And he was, part of him wanted to fire the guy, but on the other hand, he had worked there for like 8 years. He had special skills that no one else could do. And he's like, well, what if I wait and fire him, in 60 days after I hire a new person, get him up to speed? So I'm not going to share how I advise, but I want to know your thoughts on something like that.
If I take that first, I will say one of my it best doesn't equate to monetary, but I just really loved this case. And it's completely on point to what you said. So, gentleman worked there some well over 10 years, right? And he got in a car accident. And when you studied, and hindsight's 2020, everybody, we know that, right? But when you studied his performance evaluations, you want to know what they always wrote in there, or like 85% of the time? He's reliable. He's reliable. And when he gets in this car accident, he's that middle car between when you're on the freeway. So he got pretty injured. Now he's trying to recover. He's on physical therapy. He's on medication. So he starts sleeping on the job. Not okay, guy. Like, you know that. And geez, he was a security guard and he's leaving the building unlocked and bad things. Okay. But when I looked back to see what other write ups he had or bad acts, they were okay with him allegedly stealing a hammer, you know, 10 years ago. So it's like, why was that okay? And now this bad act is not okay. All right. So, but they liked him. And why? He was timely. He was reliable. What happens after the car accident? He's not. Why is he not? It's not because he's a lazy SOB. It's actually because he's injured and he's trying to recover and he's trying to do his best, working and, you know, recovering and working at the same time. So now you're using his disability against him. And
Mhm.
so that goes to your point, like, hey, I see him stealing, right? What do I do? You don't know what's going to happen down the road. And maybe 99 times out of 100, nothing bad ever comes of it. But when you got that one guy that all of a sudden you start looking at negatively, you can't, this act of overlooking the bad acts is going to come back and haunt you. And for me,
Yeah.
it did. It was interesting. I just remember it because I'm all the way up to trial, and the judge is looking at the defense lawyer going, you have to settle, right? Like, like you need to settle with Michelle Baker because this isn't going well. But it literally was the judge because they really are like, he did a bad act. He did a bad act. You got to be kidding me. Jury's not
Yeah.
going to look at it that way. So,
Yeah.
Yeah, great point. I think a lot of times we make the mistake, on the defense side, HR side, companies, where someone did something wrong and it's a gotcha, we can fire you now. Because
mhm.
oftentimes, someone does something to where you do want it to let them go, and maybe you don't have the documentation, and so you use a little small thing as an excuse. So, a couple problems there. One, with regards to wage and hour, you could have the best termination reason in the world. They could have murdered someone, as silly as that sounds. If you did not pay them overtime, if you did not give them meal and rest breaks, not only does that other stuff not matter, it won't come into evidence. We've had cases where the plaintiff was in jail suing us for wage and hour stuff, for attempted murder. And she got out. We did that deposition over Zoom, not in person, but it had no effect on the case. And so, as crazy as that sounds, so you can't use the nitpicky thing to terminate someone. And there's this case, I didn't work on this case, but someone, a company, a very big company, you can Google it, someone stole 68 cents, a 68-cent bell pepper from the company cafeteria. And the company said, "We got you on video. You stole it. You're fired." Right? Yeah, stealing, pretty good reason to fire someone. No case here. Well, he had testified that this was a practice he had commonly done. He takes it, and at the end of the week or the end of the day, he sort of trues up. Well, the jury believed the 66-year-old man who had been at the company for, I believe it was almost 10 years, and the jury awarded $26 million.
My gosh.
And so that was the biggest judgment at that time in LA. This is 2014. And so you can't do this sort of, we got you, you violated a rule. We say you can't do this in our handbook. And so it always comes down to, I think, you got to be fair with your employees, and you got to think of how a jury would, as Michelle said in the beginning, how would a jury interpret this? Really, you're going to fire this guy for taking a 68-cent pepper when he's done this in the past? And again, for wage and hour purposes, even if he did take it, he can still sue. And if you sort of rush him out the door and disrespect him, he's going to be more eager to say, "Oh, I don't have a case. Well, I'm going to sue a class action, a PAGA lawsuit, and go after, go sue on behalf of everyone just to take the company down." You don't want to have an employee, even if you have to fire them, to hate your company, right? Because they could sue you, they're going to badmouth you, they're going to post stuff online. So you want to be as gentle as possible, communicate and document when you do have to let someone go.
Yeah, I totally agree with that. How do you each feel about 90-day introductory periods? For me, like I think there are ways they used to back in the day coincide with the onset of benefits, right? But now, there's so many benefits that kick in day 1, day 5, like whatever. So, Michelle, what about you? Do you care if an employee, does it make a difference in your analysis if an employee was fired during the first 90 days versus after the magic 90-day mark?
So I see value in the 90 days, but for a very different reason. So how I'm going to answer it, correct, and let's just say there was a 90-day policy. Does it impact my evaluation? No, because what are my ears tuning for? What violations of the law exist, right? Sexual harassment can happen on day one. Someone gets a medical diagnosis, and whatever reason the diagnosis is, we all know, oh God, I'm not going to be able to deal with this person, 6 months. Oh dear God, what if the person's pregnant? And I said, oh dear God, because we know they're the most expensive lawsuits and the most successful. Okay. You might learn of that. So the point being, does 90 days have anything to do with those three scenarios I mentioned? Of course not. Okay. Why I said I see value is because what is all this about? Handling the employee properly. It gives the company that opportunity in describing with the opposing counsel, I mean, not opposing counsel, the employee, hey, you were on this 90-day period. I don't believe your services were up to snuff, and we need to let you go. But here, let me also offer you a severance. That's always key, everybody. Totally sucks, but whenever you're letting somebody go, of course, if you can give them a little bit of money and in exchange for the release, fantastic. But I find the value for the impact on the employee and not letting them think, I better call an employment lawyer because I was let go. It gives you, the employer, something to hang their hat on, if you will.
Right. Yeah. It gives the employee something to focus on. I totally get that. What about you, Joe?
So from a wage and hour perspective, it's meaningless because someone could work there for one day and still
Right.
file a class action and go back 4 years.
Mhm.
So it's you have to be careful even in that situation. From a wrongful termination standpoint, I think plaintiffs' lawyers are more like, if I'm going to speak on your behalf, Michelle, you,
Oh, go
you'd,
ahead.
you'd much rather have the employee who worked there for 30 years
Of
than 30
course.
days, right? Because that's the fairness level changes,
Hmm.
right? It's you can be quicker to fire someone who was there for 30 days or 60 days than someone who was there for 30 years.
Right.
Um, but I think again goes to communication. You want to let them know we're going to be evaluating you. There's no guarantee here. Everyone here has at-will provisions, but people don't really pay attention to that. And so it has to be we're going to try you out and you're going to document things, and there's got to be a reason for ultimately deciding. There's a misconception. Yes, California is an at-will state, but don't fire someone for no reason. That's one of the worst things you can do because no one tells the employee we're firing you because you complained about not getting breaks. They always, hopefully they give a reason, but also not giving a reason can create problems as well. So the 90 day, I mean, I it's meaningless legally. So you're right about that, Linda.
Right.
Um, I don't mind when a company says, hey, we're putting you on a 90-day introductory period. After 30 days, here's what you didn't do. After 60 days, hey, you're still not doing this. And then 90 days, listen, you weren't able to get to where we need you to go. We're sorry. We're going to let you go. Yeah, I'd prefer that. And I think Michelle said maybe one of the most important things from a wage and hour perspective, severance agreements. Because again, the whole goal, we got the World Cup final coming up. Employers need to block former employees from going to Michelle. We do
Yeah.
not want to get them to Michelle, as lovely as she is, and you don't want to have to deal with her.
Mhm.
So I would always joke with clients, deal with Linda because you don't want to have to deal with me. Linda's much more pleasant. She's going to prevent the problems from the outset. Um, but you also don't want to deal with Michelle because she's going to come after you if there's a violation. And if you sign a severance agreement, 99 times out of 100, that's going to prevent the lawsuit. There are exceptions.
Yeah.
Right. Yeah, and let's also talk about a different type of agreement. How do you each feel about arbitration agreements?
So,
Michelle lit up on that question.
well, yeah, no, well, the reason I did is when Joe was speaking, I actually was thinking of that, right? We talk about the back end, but there's a very important document in the front end, okay? And it's really rough with arbitration agreements for the following. Um, as you know, like if we talk about wage and hour issues, I'm not even sure there's any insurance that exists if other than maybe some defense costs that kick in, but they're not going to pay for it. So the companies are liable for those damages. When you throw in an arbitration agreement, the employer is also responsible for these fees. It's very costly and expensive. However, having an arbitration agreement and when you're dealing strictly is the key word with wage and hour issues, they are valuable. Why? Because it allows you to say not have a representative action. Okay. And so you've got that benefit. Now, from my standpoint, I don't care whether because I don't, anyways, I just don't care if there's arbitration agreements involved. Um, Knowledge of it evaluates, for me, I use it to evaluate what the value of the case is. But the reason I say I don't care is there are some claims that are better suited in arbitration. And you're also looking at the value of the claim. So don't forget, a lot of plaintiffs' lawyers know if there's an arbitration agreement and Joe, I'm not sure what to say. How many cases are like maybe I guess probably a majority of cases are valued less than the ultimate fee that an employer would have to pay for arbitration. So employees, their attorneys, are using that situation to say, hey, pay me 50, 60, 70,000 bucks because you know you're going to pay 100,000 down the road. And you all know it's true. And now you're getting blackmailed because you have an arbitration agreement. So the whole thing's just weird. But it really is looking to me the best advice I'd give to a company is look at how you run, look at how you assess risk and weigh that balance if it makes sense, and also knowing where your employees are, right? Like, you don't need to be concerned. If you've got employees in Orange County, it's a very conservative court. Do you really need an arbitration agreement? Those people in LA do,
Yeah.
and it, so that's my commentary on it. But a lot of lawyers hate seeing arbitration agreements. Maybe it's enough to have that because of that. I don't know.
Yeah. Joe?
Totally agree with what Michelle said. I think good plaintiffs lawyers don't care about arbitration agreements. Um, and I think they can backfire. Having said that, um, I like arbitration agreements. It used to be for two reasons. For sexual harassment cases, to
Mhm.
where a jury was going to get really upset, right? So in arbitration, you have usually a retired judge or at least an experienced lawyer that's deciding things sort of privately, instead of a court, no jury. So the value was you don't want to hear a jury hear about the sexual harassment and get so upset they, forget damages, right? Because it comes down to damages. They're just so upset. We're going to ignore the law and send a message, right? So you wanted to have in sexual harassment cases, have those in arbitration. The arbitrator is usually going to be a little more measured. Um, and this goes to someone's question in the chat. There is a law, a new law that says you cannot arbitrate sexual harassment cases. So that eliminated one of the most important reasons for arbitration agreements. And whoever asked that question, you're right. Plaintiffs' lawyers are adding that in there to avoid sending the entire case to arbitration. So it's a smart move, frankly. Um, the reason I still recommend it for most companies that have, well, let's say 50 or more employees, maybe more. It depends if they're hourly, depends on, like Michelle said, where they're located, is an arbitration agreement can defeat a class action. So
Mhm.
going back to class actions and PAGAs, it's the most boring area of employment law, but it's the one that costs companies the most. If you have an arbitration agreement, it and it has to be an enforceable good one, you can defeat a class action. Well, you still have PAGA, but the class action goes back 4 years. They can sue you
Right.
for 4 years in the past. Remember that employee who worked for you for one day? Well, she can sue going back 4 years and ongoing through the entirety of the lawsuit. If you have an arbitration agreement, you can have something in there. It's called the class action waiver, or technically, if it's silent as to class actions, and say, no, it's got to be one-on-one. You can't do a class action. Um, PAGA, you can still, the California legislature said, no, that doesn't apply. It was argued in the California Supreme Court, US Supreme Court, years of litigation. It's still valuable for me to eliminate 3 years of liability. But yeah, I've had a plaintiff's lawyer in a wrongful termination case say, we're gonna compel arbitration. And he said, Joe, our demand is $40,000. We're You're going to pay $70,000 just to the arbitrator. And we thought
Right.
about it. I'm like, yeah, we're not going to compel arbitration. And then he said, I'll compel arbitration. I've never heard a plaintiff's lawyer say they were going to compel arbitration before, but that's because he knew it was going to cost the
Right.
company 50, $70,000. And so it's, yeah,
Just
we
to pay
settled.
the arbitrator. Right. Not even
Smart move.
getting to your fees or anybody else. Yeah, Michelle.
Were you concerned about the them compelling arbitration? Meaning, because if the defendant doesn't, see, that's what's interesting with this arbitration agreement, and I was thinking about it when I was speaking, is the employer still is in control. If they don't pay the fee, they're now in court and they could do it. I can't stand like the blackmail aspect. Sorry.
Yeah.
I'm a lawyer, but I can't lie. And it's real. And
Yeah.
the blackmail, it drives me crazy. And I've heard that, Joe, but I'm like, I think the best way out for the company is simply, I'm not going to pay the arbitration fee. Would you agree?
Yeah, I think you look really bad in front of the judge if that happens and you're trying to force a lawsuit,
Hmm.
to say, no, 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 we signed this agreement, but we don't want to pay for arbitration. Now you could say we don't have the money to pay,
Hmm.
right? So there is a world where it does work. In that case, we settled, it was
Hmm.
a move
Hmm.
for him. But yeah, I mean that it's never happened to me all the way, but I wouldn't want to look bad in front of the judge.
True.
Nor obviously my clients look bad in front of the judge. So, but
Right.
I think it comes down to you need to individually assess whether arbitration agreements is right for you. If you
Yeah.
got 30 employees and you're not too concerned about wage and hour stuff, I probably wouldn't do it. If you've got 200 employees and a lot of them are hourly workers, it's totally worth it, in my opinion.
Yeah. Okay, great advice. Let's say you guys, we do a lot of audits. I don't know how often you guys audit, but if you were to audit, employers tomorrow, you spend the day going through different employers, what's the one thing you're going to find that they're not doing right? What's the one violation that you see more often than any others? Like for me, I think it's regular rate calculations, right? People don't know that they need to pay overtime and other things at the regular rate of pay or even what that is. So we see that a lot. We see I-9 form issues a lot and probably meal periods. Those would be some of the things that we see most often. What are you guys seeing?
So I'll jump in first, Michelle, if you don't mind. The biggest challenge, I don't know if I see it the most, but I see it a lot, is companies don't monitor their meal periods, and they just say, we have a policy in the handbook. We tell employees they can take their meal periods, and then that's it, right? And then they'll get this letter saying, I didn't get my meal periods. It's a PAGA. And I've been on the phone with an owner of a business, and he says, they can take their meal periods. I bought the handbook online. We have the policies. They get, they have the right to take their meal periods. Okay, let me get their clock in and out sheets. Sometimes, well, we don't have those, or sometimes I see 8 to 12, 12 to 1 out for lunch, 1 to 5 on the dot every time,
Every day. Yeah.
every day for 2 years. That's suspicious. Or there's time rounding, which I highly don't recommend. But then you'll have people taking late lunches, right? Let's say, or taking a lunch shorter than 30 minutes. Late lunch meaning usually after the fifth hour. They have to take meal periods before the fifth hour. And so, a business owner will say, well, that was up to them. And well, they're not going to say that, right? They're going to say they had to because things were so busy. How are
Right.
you going to prove it? How are you going to show that it was their choice? And then you're in a very difficult situation where it's your word against the employee's word. And if the records show tons of late lunches and you were never paying penalties, that's the biggest problem. When I have a client with 100 employees and no one's ever gotten a penalty payment over the past 4 years, you're not paying penalties. You're
Right.
not complying with the law in that situation. Because surely in the past 4 years, one of your 100 employees wasn't able to take a meal period. So I actually like when I get the records and I see, oh yeah, we paid this one out. I like seeing certain penalties because it shows you're complying with the law, and it shows, well, hey, when this guy missed a lunch, we paid out the penalty. We're doing everything right.
Yeah. Yeah, we see people. I mean, this was a weird one. We did an audit probably 3 months ago, and they said, "Oh, our attorney gave us a waiver so people could like voluntarily skip their lunch." And I was like, "What?" Like, let me see this waiver, right? So we see, a misunderstanding over waivers and when they can be used and when they can't be used. So that's another one that we see around that. Michelle, anything that you see commonly?
So for me, no, because I don't I don't know, but I am going to draw on my personal relationship with my husband. And when we have pillow talk, it's very boring. It's about employment law. But no, what I hear a lot of times is the off the work clock.
Mm.
And, employers frequently are going to say, we don't allow off the work. Are you kidding me? You clock in and out whenever you want to. Okay. And you can have a video camera that says that. You can have your clock in and clock out. But what's dangerous on those claims, and by the way, I think plaintiffs lawyers who are targeting that are going to be looking for bigger ticket items, 100 plus employees and stuff. But
Hmm.
how do you prove that they didn't work off the clock? And because apparently the plaintiff's lawyer is going to have someone who says, I'm working off the clock, which, by the way, don't forget, what does work mean? Does it mean being on a computer? Does it mean, cooking in the kitchen? It, of course, but guess what it also means? Waiting in line to punch out, waiting in line to punch in. That's compensable time if it's unreasonable, if you will, or the donning and
Yeah.
doffing of uniforms, etc. So when someone says, I got to wait in line to get my equipment to use or my tools, but I'm not paid until I get to that clock in and out, that's a problem. So
Yeah.
I'm informed and believe that that seems to be something big is creating the off the work clock. I mean, off the clock
Off the
work.
clock work. Yeah.
There we go.
I think everybody understood. Yeah. And again, we did an audit recently where, sort of what you're saying, there's a limited number of time clocks, right? So there's a little bit of a line, not too bad. But what it does do is it allows people to clock in. And so let's say they clock in at 3 minutes before their shift starts.
Mhm.
That also means their meal period has to start 3 minutes earlier to be
Correct.
compliant. And a lot of employers don't get that. I didn't get that until, I don't know, 5 or 6 years ago. And I sat through a seminar. I was like, oh my gosh, like that's right, right? It would be at the end of the fifth hour. So there's a lot of things you got to always keep in mind there. We only have about 10 minutes left, and we did have people that sent in questions ahead of time. And Denise, if you can take a look at the ones that are in the Q&A section and help me out there, I'd appreciate it. So let's see. Gladys asks, we currently have the supervisor submit time cards for the entire crew. Is this okay, or should we reconsider having the rest of the crew submit individual time cards too?
I, I don't know if there's anything wrong with someone just sort of taking them in, but I would want something from the employee that says, yes, these hours are accurate. Well, you have to assume with wage and hour stuff, and Michelle's not that type of lawyer, but they're going to assume the worst in every case,
Mhm.
right? Because they're advocating on their clients. Their goal is to get their client money. Um, if there's a situation where they can argue that, oh, you just did that, or that manager was just taking it in and perhaps, you know, writing over because he would get in trouble if employees, submitted too much overtime, stuff like that happens a lot in the big retail companies because they've got an overtime budget. You're leaving yourself susceptible to someone lying, and you don't want to leave yourself susceptible. So in that case, I mean, I'm okay if it's physically handed in, but there should be something where an employee signs off. I got all my hours, I got all my breaks. Even that's not perfect, but it's better.
And most payroll companies have the ability to allow an attestation to that effect. So like you go to submit your time card and you have to attest to these were your hours, blah, blah, blah. So hopefully they're doing that. Now she had a follow-up question that said, we had time cards that included a lunch in and lunch out section, but the field crews never bothered using it. How critical is it to have this feature back on the time card so the actual meal breaks are reflected? Michelle, want to take that one?
I was getting excited over that one.
But my God, like that's where we go back to because what did we start with in the beginning of this discussion? It's managing your managers. Okay. Yes, when people aren't, and especially my God, when you know that people out in the field aren't doing their clocking in and out properly, unfortunately, that's either you or a manager needs to be out there managing that because that is what the biggest problem is not everyone's happy, and there's a lot of people that want money grabs, and you have no idea why someone wants cash. That's a ripe situation for a worker out in the field to take advantage of and use that to say we're forced to be here or, this or that. But you gotta be on top of it because you're gonna get hit in that scenario.
Yeah. I mean, that's a straight up violation of labor code, right? So they need to make sure they're reflecting that.
I
All right.
will say though, one thing like, and just heads up, and I have no idea what the cost is, but I do see employers being creative in how they are, using technology, I guess, to track that work, whether that's the GPS or cameras in the truck, or maybe cameras at the job site. There are ways where you don't have to have that human running around out there making sure. But if you don't, you better have the technology in place to capture that the brakes and everything are being taken properly. So.
Cool. Kristen asked, she said that they write manual checks. They use manual checks for the final checks for employees, and it comes from their company stock, which has a mailing address on it, but not a physical address on it. The pay stub for the final paycheck would have the correct company's physical address, but does it matter if the address on the actual check that's produced has a mailing address? And so I'd never even thought about that one. Either one of you know?
My comment would be is to have the proper, not just the mailing address, but the proper company address on all of that stuff. I know there are lawyers out there that are going to pick up on that and figure out that there's a discrepancy and use it against you. There's no reason why not to have that proper employer address, obviously. And the reason I'm stressing that is the number of times I get a paycheck. I'm like, who the hell is this company? What is this? Oh, and by the way, it causes me to loop in other companies that may not otherwise have liability. And I understand you're saying like a mailing address, but
Yeah.
my point is why it's so important is because it causes lawyers to go down into a rabbit hole and almost expand who that employer can be and then use it as a violation that I don't really know who my employer is when it's the wrong
Got it.
address.
Yeah, I mean, if I
Joe?
if I had to defend it, I think we would prevail on that issue of the
Mm.
mailing address, but
But
that's not a win to me because that's going to cost a lot of money, and they're not going to sue for just that. The plaintiff's lawyers, there's typically about 8 things that they sue for, and if they
yeah.
win on one, they get their attorney's fees. So
Mm.
I would figure out a way. Okay, if it has it on the check, I don't care. But on the pay stub, even if you got to write it in manually when you give someone their
Mm.
final pay stub, I would do it just to not give
Yeah.
them an opportunity to argue something. Even if you think you're going to win, you want to eliminate the argument.
Exactly, because
Yeah.
it's triggering a plaintiff's lawyer for studying it more closely when they otherwise wouldn't. That's what you're avoiding. That's your audience on that compliance issue.
Yeah. So, okay, switching gears a little bit, Esmeralda has a question regarding split shifts and temporary additional assignments. That's the phrase she uses. So she apparently has a janitorial company. She'll have people scheduled at say 6 to 10 p.m. And then I don't know, for whatever reason, they need somebody in the morning that same day, 8 to 10 a.m. This person like volunteers to come in and work that extra shift. So without going down the rabbit hole of how to calculate split, shift premiums or something like that, the first question would be if the employee volunteers to work that temporary additional assignment, can you just document, hey, they volunteered to do it, and that makes it not a split shift? That's essentially, I think, what first question is.
No, but I'll I don't care what you call it. I'm looking at like the whoever volunteered or whatever. I'm looking at what's the services being performed. It's the benefit of the company. But Joe, what do you think?
Yeah, split shifts are incredibly complicated. You got to be careful. But if a split shift is voluntary, if someone says they want to do it or come back, and and they're the ones that you can prove that it was their choice, then I think you have a good argument. But I would, from a best practice standpoint, I wouldn't do it. If it happens, once or twice, then fine. But if you split shift is when someone works, one shift and then they go home, right? And they have to come back 3 hours later, something like that. The law says you've got to pay a premium for that, depending on how much more they make than the minimum wage. And so whether that constitutes a split shift, yes, if someone says, "Hey, I want to come back to work," right? To work a couple hours, sure, probably not a split shift. But a lot of times companies will say something is voluntary and an employee feels compelled to do it.
Mm.
I
Right.
can tell you, when I was just starting out, there were a lot of voluntary things that I did that I did not want to do. but you did it. And so I'd
Absolutely
be careful.
correct.
All right, great. All right, Denise, and Esmeralda, I know you had some other questions in there, but just you can reach out to one of our attorneys here, and I'm sure they'd be happy to answer those questions. Denise, do we have any questions that are quick that we can
Yeah.
answer? And while you do that, I'm going to go back to sharing my slides again.
Okay. We do have a lot of questions. A lot are specific. So I did drop the information for your contact information into the chat for anyone who needs to follow up, because we won't get to all these questions. Let's see. We had PAGA is a big thing. Is there a time frame on which an employee can file a class action lawsuit regardless of how long they were with the company?
So class action, they have 4 years. It's technically 3 years for wage claims, but you can sue under a different law that makes it 4 years. PAGA, it's essentially 1 year and 65 days for the letter to the LWDA. So from a safe standpoint, there is someone that if you fired them 3 years and 364 days ago, they could sue you if you didn't pay them their wages.
And is there a limit or a number of employees that can file separate lawsuits for PAGA?
No, everyone, well, any employee can file a PAGA case, whether it's whether it's a one-person company or a million, right? It's class actions, you have a numerosity requirement that you could try to knock it out. But sometimes you'll have multiple employees file competing PAGA actions,
Mhm.
and then that sort of becomes a gigantic pain in the butt where you have to either relate them or consolidate them or go to mediation on a global basis. But no, technically, they could all file separate PAGA actions and make life difficult for companies.
Okay. I'm trying to find some quick ones. How long do we need to keep payroll information?
We recommend 7 years on everything for the reason Joe just said. There's time, you have so much time to file, so much time to serve, then go like this. And then you don't want to be stuck not being able to, back yourself up. So 7 years across the board is what we recommend. You guys have a different opinion?
I also recommend 7. I do believe the law is like half that time, but you
Yeah,
shouldn't, you're doing yourself a disservice. Um,
agreed.
I've always thought of the 7 as well.
Okay. Makes it
Uh,
easy just to cover pretty
oh,
much everything. There are a couple of exceptions, but for payroll records, yeah. Yeah, Michelle.
What I was just gonna say, like I'm actually involved in a class action where they switched payroll companies and they don't have access to their pay records. Okay. So my point in saying, hey, best practice is you keep your 7. Why? This is less than the 7. They don't have it for other reasons. And of course I get
Right.
to use it against them. Like it
Yeah.
becomes the word of my client because you don't even have now the proper backup. So and that's actually a note of whatever a public service announcement where if you're switching payroll companies, make sure you get that information
Yeah.
for yourself from that payroll company and do not rely on them to think they're going to have it 2, 3, 5 years down the road.
Yeah,
So,
exactly. They're not going to keep it for you, and there's a fee
yeah,
involved. That's why a lot of companies don't do it, but we always recommend it
yeah,
for a lot of different reasons, but specifically that.
yeah.
So I'm going to cut us off here because it is noon. I'm going to just share a couple things with everybody. First and foremost, Joe and Michelle, thank you so much, and Denise as always, but Joe, Michelle, thank you so much for sharing your expertise with us. Really appreciate everything. You guys have their contact info, so if you need to reach out, I'm sure they'd be happy to take an email from you or a call from you. Ethos is launching its fall management development series. Manager Toolkit 1 is 2 days. I have the dates there. Manager Toolkit Level 2 is brand new and it's 1 day. And then we're going to be doing everything desk management. So if you're interested, there's a link there where it says more info or to register here. That will get you to the homepage. It has the pricing there and everything else, or you can just simply email me. Next month, we're doing a webinar on the 20th at 11 a.m. And we're going to go back to tried and true topic. They think they're exempt. Think again, right? So I know there were a couple questions today regarding misclassification issues and things like that. This one's going to be done with Marla Merhab Robinson, my old webinar partner. And there's a registration link in where it says here. So again, thank you all so much for attending, and thank you all so much for sharing your expertise with us. Really appreciate it.
Thank you, Linda, for the opportunity.
Thanks,
Have a great
everyone. And
day.
don't forget, we'll post this on the Ethos YouTube channel if you have questions.